Welcome to QLTS School's video series on the SQE1 Assessment. Today we'll look at a sample multiple choice question on business law and practice.
You act for a private equity PE house. Your client is investing in a technology startup company, Target, in return for a 20% shareholding in the target. As part of the transaction, your client wishes to have a director appointed to the board so that the PE house can influence and observe the progress of the company. The target agrees, and this is included in the investment agreement. The investment agreement also includes the following clause. The company's liability for any matter arising whether directly or indirectly under the terms of the investment or this agreement is limited to £1. After making the investment, the existing board then refused to appoint a director for the PE house. Which of the following answers best describes your client's best remedy? A. Your client has no available remedies. B. Your client may bring a claim for breach of contract. C. Your client may bring a petition to wind the company up. D. Your client may bring an unfair prejudice claim. E. Your client can seek to amend the company's articles of association so that the PE house would then have a right to appoint a director. The best answer is D. Your client may bring an unfair prejudice claim under Section 994 of the Companies Act 2006. Such a claim can be presented by a member if the concerned company has caused an unfair prejudice to be suffered. The PE house purchased shares on the reliance that a director, with the intention of maintaining the PE house's interests, would be appointed to the board following completion of the investment. The fact that the PE house has subsequently been excluded from having such an interest is an example of unfair prejudice. The court's powers are wide if it finds in favour of a petitioner in an unfair prejudice petition. Generally, this is expressed as such order as it, the court, thinks fit for giving relief in respect of the matter complained of. This can include regulating the conduct of the company's affairs, ordering the company to do or refrain from doing an act, or even providing for the purchase of any shares of any members of the company by other members of the company itself. Section 996, subsection 2. Answer B is also correct in principle. A breach of contract claim can be brought against the company, but as the company's liability is limited to £1 under the investment agreement, it's unlikely to offer an adequate remedy. Specific performance may still be an option, however, any pecuniary losses will be capped at £1, thereby rendering D the best answer. Answer C is correct. Your client may petition the court to have the company wound up, but this is not the best remedy for your client, as they may not receive a full return on their investment once the company's creditors have been paid. Answer E is incorrect. To amend the company's articles of association requires a special resolution to be passed by more than 75% of the company's members. The PE house holds 20%, and therefore is unable to consider such recourse without the backing of other shareholders.